Say and spell and pronounce your name for us.
Charles Schmadeke, Schmadeke.
And that's Charles. When you're on the news, it's Charles.
That's correct.
Okay. What do you think of what you've heard?
Well, I believe that both parties presented their arguments to the judge, and Judge Schmitz is a very thoughtful judge, and he'll make a decision that he believes the law justifies. And we are confident in our position, and we'll have to wait and see what happens.
Did I hear him correctly? He agreed that he also was aghast at the hardship?
That's the way I understood it.
That's what you said. You said you're...
And I believe he agreed with that statement.
Well, what was it the state said that you took issue with in there?
The state said there were, in essence, no hardship to the superintendents. And that's what I found to be appalling.
How so? Why?
Because there's a clear hardship. People have been working close to 2 months now without pay. Any person could put themselves in those shoes and see how difficult life can be. This is a severe hardship to the regional superintendents and the assistant regional superintendents.
The judge seemed to hint that the question is not hardship, but does he have the power to order the governor to spend money? And there just doesn't seem to be an answer in the case law.
Well, our position is that he does have that power. And we believe that there's precedent that says when the General Assembly gives a command that so much money should be paid, you don't need an explicit appropriation to disperse the money. We've given the judge that authority. We hope he thinks that's persuasive, but we'll have to wait and see.
But why would the governor have to follow? I think the judge's exact word was, what if the governor says, I mean, what about that?
If this court decided to enter an injunction and the state officials decided not to abide by his injunction, we believe the court would have the power to take necessary action to enforce his orders.
Does this in effect rewrite the appropriations process, though, to say that the governor can veto an appropriation and that doesn't have any real effect?
Not at all. Not at all. We believe that there is an appropriation process, but what we're saying here is that there is precedent that says that an appropriation is not the exclusive way to have state warrants issued. As long as there is very clear legislative direction to pay certain amounts of money, then that suffices for the issuance of state checks.
This is a state that has
a law that says there is hereby created an office of regional superintendent, and
they shall be paid the X amount of dollars. That's correct.
Why does that take precedence? Why does they shall be paid take precedence over the appropriation?
Because that's the expressed will of the General Assembly, the people's representatives.
This is a state that has $4 billion in unpaid bills sitting. You know, why is this such a special case that these people should get to the front of the line when a lot of other people in the state haven't been paid in months?
Well, these people hold offices that the General Assembly created, and they're doing the job of the state of Illinois. The Illinois Constitution says that public education is the primary responsibility of the state. As I made the point to the judge, the job of the regional superintendents is an extremely vital cog in the machinery of public education. That's why. We're not asking that nobody else be paid. We're saying that the will of the people, as represented by the General Assembly, should be enforced, which is to pay these people what their statutory salary is.
One of the suggestions you made was the State Board of Ed's Personal Services Fund. There was the suggestion from the state that could leave that fund depleted and unable to pay State Board of Education employees. Is that a legitimate concern?
Well, not now. We're only asking for temporary relief. You know, and that means until the judge can really decide the full issue, the hearing on the merits, that's what we want, you know, temporary relief. So that wouldn't exhaust that fund at all. We're talking a very brief period of time, so maybe a month or two.
That reference to mandamus, how long would it ordinarily take to go through a process like that?
Well, that's dependent upon how the parties decide to move on the case and the court. The one thing that Mr. Corrigan said is correct. We could move that case quicker, and we may think that that's an appropriate response, but we don't want to make that decision until we see what happens tomorrow.
You're just giving him options for ruling for payment in the case of the TRO.
Yes.
The personal services line.
That's correct.
Not necessarily that.
Well, we gave them two options. The commons, correct. We gave them the option of the common school fund or the personal services line item. Frankly, if they think they can use other money to pay this lawfully, that's fine with us. We're not wed to any concept. We want to see our people paid for the job that they're doing and in the way that the legislature says they should be paid.
What's it come out of in the past, common school fund?
Common School Fund.
And you're not even seeking at this point the pay that already has been missed since the end of June, you're just looking for all paychecks going forward?
That's
until this
correct.
needs to resolve.
The back pay is not at issue presently.
Now, you mentioned that the money that the governor cut is still in the general, the common school fund. So does that go towards your argument that you should be getting paid the money currently? It doesn't really matter.
Well, I believe that the state and then the judge asked the question that, or raised the point that we would be taking money for the school aid, and that's just not correct, because the money that the General Assembly originally appropriated from the Common School Fund is still there. So we're not imposing any harm upon the local schools.
To be clear, if the General Assembly did wish to rid of the regional offices of education, the superintendents, what have you, it wouldn't be through this process. You're saying they'd have to go through, write a separate statute and reverse current law, so.
Well, the General Assembly has the ability to create offices, and it also has the ability to eliminate offices. Our point of view is that is a legislative function, not one of the executive, and especially one where the General Assembly has been so specifically clear about what people should do and how they should be paid.
Are you familiar with the Supreme Court ruling that the state cited that says even though power can be abused, that doesn't mean the power doesn't exist?
Yes, in fact, we pointed out to the judge, our opening brief quoted that language where the Supreme Court said it's inconceivable that a governor would take action to not fund essential functions of state government. That was an opening line in our brief. We believe it is inconceivable, yet that's exactly what we're confronted with, and that's why we are here asking this court to give us the relief that we need.
Was that quoted in context then? That, the way he said that? I mean, do you,
So you
I'm
know
asking you
the
what the
governor has
Supreme
the
Court.
authority to do what he did.
We don't dispute that the Constitution gives the governor authority to engage in item vetoes, correct. But we're saying it's without consequence in this case because the General Assembly has given other expenditure authority that could be used to pay our people.
Can you explain to me the issue, and I don't know, I could be off here, of timeline, in the sense that the governor issued a veto the day before a lot of the regional offices, or regional superintendents were sworn in, correct?
That's correct.
So does the during the term of office argument apply in the sense that, I mean, if their terms expired at midnight and they were sworn in after the veto, they were sworn in with no salary?
Well, we haven't raised that issue at this point in time. In fact, we had a lawsuit that filed last spring where we raised that particular thing. We haven't raised it now, and I'm not saying we won't raise it in the future, but as of now, we're talking about a new term of office, so there's been no reduction or increase in the salary where we think that the constitutional prohibition may be implicated. But if necessary, we'll review that more and see if there is a cause of action for that. But right now, that's not at issue.